Hello, loved ones. So, where are we at with today? Well, we're talking about our affidavit. We're talking about why this particular thing is really a necessary tool that we got to use to get ourselves into the door. This proverbial second door that we all should have chosen when we were younger, but we failed to. So, what we're going to talk about first, though, is my camera's on. Yeah. We're actually going to talk about this bona fide protected purchaser for value for just a moment without notice and why this is important. So, this concept of you being a purchaser, he who parts with consideration or she that pays is entitled to something. The moment you pay for something, you're either owed some kind of duty, a service, an item, a piece of property, I don't know, something. But as part of this transaction, when one interest leaves one party, as in here, I just parted with a silver coin, that buys you, literally, it purchases for you a very powerful position because it removes you out of that common law debt side of the ledger. I know Stuart Romley from the Justinian program there, I think that he's running. He does a pretty good breakdown on the ledger. And if you have any accounting type background, you would definitely quickly understand what that's all about. Dean probably touched on that back in the day, but again, that's not what we're here to really just, tear into that. So I did want to take just another moment here to clarify the purpose of this particular chat. Okay, this one, the live version, I'm trying to gear it not so much with respect to our personal stories. We've all got personal stories. We all share almost the same story, believe it or not, loved ones. We're all sharing a common interest here. We're all trying to get through this gate and leave that other world behind. We know every one of us has suffered some kind of trauma. Every one of us has gone through some incredible ordeals, these life experiences. We all have them. You're not a whole lot special because of your particular set of circumstances. You know what? Because they're almost a carbon copy of mine. And Kim's is almost a carbon copy of Bryce's. Again, it's all about us leaving that system that we were birthed into. We can just set aside, if you don't mind, a lot of the drama that goes on the Telegram chats. And again, that's just part of the social media platform. It's not that we're here to do something very specific and as quickly as we can. This, believe it or not, loved ones, is why, okay, just consider this for a moment here. Dean and I have gone through this entire process once, 15, 20 years ago, when no one ever knew what any of this shit was about. Dean and I were already doing it, okay? And then it got to the point where we got overwhelmed with the responses, and then things didn't quite work exactly how we envisioned them to back then, and everything kind of just went sprinkly. And here's a lot of the reason why. A lot of peripheral distractions start to come at us. And when you start to deal with people that aren't quite in the energetic alignment with what we're trying to do, it creates a lot of static. It creates a lot of distraction. It creates a lot of heartache. It creates a lot of stress. Can you imagine when you get hundreds of emails and correspondences, almost daily with people with, I need this and that and this and that. So, okay, we know we've actually boiled it down to everyone is experiencing one of the 5 same things, or maybe 2 of the 5, maybe even 3 if your things are really going sideways for you. Point being, this is why when I set out to do my part of this mission with Dean, I found it to be very, very important that I created a spiritual wall of gifted women who are very intuitive. They have incredible mothering and nurturing skills already. They have incredible gifts that they're not afraid to use and not afraid to stand up for and enforce. So then when I started to see that and I mixed the equity stuff in with it, these women, these queens are here to manage that whole wall. Again, if you're familiar with Game of Thrones, right? When you got sent to the wall, it's because that wall was something very important. The rest of the kingdoms were able to live in peace because of that wall. It gets to be very consuming when you're dealing with people's emotions and people's lives. And when someone's about to lose a child or a house, or they just lost their house or lost their child, right? Okay, so you can imagine all the emotional things that we go through here. So now when we come across as I don't want to say harsh. Harsh isn't quite the right word. But when we just are trying to steer this boat in a very specific direction, it's for a reason. Because I've already been here, done all this once, probably twice, which is why the third time now we're going to get this time. So this is why it's important that these women, these queens and men and guys, I know again, this is this team that we're talking about. So when we have the drama come into the live portion of our of what we're trying to teach here, it kind of gets in the way a little bit. Take that to some of the other chats and let some spiritual guidance programs help you there, because I'm not in charge of the overall spiritual guidance programs. The other 70%, yeah, I oversee a lot of it in the background, but that's not my focus. My focus, as Jody and the queens are describing here, is I'm feeling like the equity paperwork side of all this it encompasses about 30%. We need it to become a whole other better individual spiritually. And once we do that 30%, that 70% just works. And when you do it together, it's a very nice little package. If you try to do one without the other, you're prone to being attacked a lot, and things become very distracting. Things are not settled. They're not flowing the way they should be. They're not coming to you as simply as they should. And that's what we're here to do, is try to help streamline a lot of that stuff. Push the drama aside, because we all have it. If you have an extraordinary set of particular circumstances that demands immediate attention, please bring it to our attention. But again, do it in a manner that's not coming across as being very selfish, you know what? Because that is kind of being selfish or needy. And we all have the same problems. So when we start acting as a team versus kind of attacking each other and, oh, this, that, and the other, and you hurt my feelings over here. Okay, the feelings aside, let's keep the live chat, this program, more about business. I know there's a lot of emotional charge to this business, but just kind of stay on one side of the fence or the other. As soon as we start to mix this stuff, I need these women putting together documents. Like, as this one was going live, I just say to Kim, now, Kim, go back into Gibson's Suits and Chancery book, pull me pages 72 to 80, because I'm going to talk about that right now. That's the bona fide purchaser for value stuff. So Kim, as the meditation's going on for you folks, she's in the background whipping this together so that I can talk about it right now. I don't really have the technical skills to really be able to do all that stuff. That's why these ladies are here. And I'm very choosy with who is where and why and what skill set they bring. Again, I feel like I'm being charged to put a special forces team together of women that know how to kick some serious ass. They're very intuitive. They're very emotional. They're very spiritual, but they also get the equity thing going for them. Haha. Well, that's what I'm saying. You do not mess with these women. From everything that I'm looking at and how balanced and how there they are for each other. If you call out one, you just call them all out. So be ready. I'll get involved once in a while, but you know what? Again, I got better things to do, like find proper statements of interest out of Gibson's book and correlate it with Pomeroy's shit over here so that it all supports Joseph Story's comments. Boom. You're like, what the hell are you talking about? Okay, these are all chancellors. These are all guys that have incredible backgrounds with equitable jurisprudence. Again, Joseph Story. This guy's like 30 years old, 100 years ago. He's a Supreme Court justice at 30 years old. Are you kidding me? The skills that these guys had. Anyway, so you see how I'm a little bit preoccupied, and it's not that we don't care. It's not that we're not sensitive to your personal issues. Yes, we are. But you got to understand there's a list of people, and you just happen to be one of them on it. And we're doing everything we can to encompass the priority of things. And it got to the point where, you know what? I'm actually doing everybody a disservice when I talk to people one-off. That one-offness is what's literally robbing you of an opportunity. Every time I get the, hey, Darren, what do you think about this? It's like, yes, let's bring it up on this chat. And again, it doesn't matter to me if there's one person on here or one individual on here with me watching this. It doesn't matter. I would sit down and do Zooms with myself just to record them, just to post them on ShitTube so that you all have a chance to hear it. That's my entire goal. So whether there's 1,000 people on here or it's me, it doesn't matter. The fact that you're all here to be a part of this experience is what, impresses the shit out of me, which is why, again, I'm motivated to help people as great as I can. But I found, as Dean would attest to, it's much better to help the whole. And then you have the whole that can help you. Aha. And I'm experiencing that firsthand with the development of these lovely ladies in the background. Who that when I do this, things just appear on my computer, and I get to relax a little bit, and I say, oh, all I have to do is talk about the doctrines and jurisprudence of equity. Well, that's the easy part. I only figured out how to send an email out about 3 years ago. So I've actually made incredible progress at the fact that I can share a document now. Oh, yeah, see, we all have. There's hope for all of us. Okay, so drama set aside. I'm not, again, if it's an emergency and you throw something up on the Kindergarten platform and the Divergence Live platform and all, if you pepper something, all fine. But again, let's just keep the personal stories for a different platform. That's all. So I think I got that one pretty much pegged.
And Kim has some little goodies she's going to drop for you, loved ones, in the chat. So head there now. We got 2 documents we want you to take a peek at. We want you to get your eyeballs on these, as Darren says quite often, so that you can take a peek at this and he can walk you through it. This is going to be a huge part of the petition. Do you want to explain why, please?
Okay, so again, the petition, which we're going to talk about later this evening, its backbone is the affidavit. This affidavit, it's the real deal when we do these properly and when we have them endorsed by a notary. Now, again, I'm going to suggest this is probably the easier way of doing this. Why? Why do we want, Darren, why do we want to bring the public notary seal into our paperwork? Well, A, we can kind of get around the publicness of that seal when you actually request that the notary sign within the jurisdiction of the Dominion of Canada, or for maybe you Americans, try the Republic of the United States of America. Try getting your notary to sign off on that. You know why? Those jurisdictions still exist. They're back there. They're there. But just no one's sitting in any of the seats in those big auditoriums. Those chambers are full of dust. No one's been in them for a while. So again, the affidavit is the mode or the particular instrument that acts as a conveyor. It's like a transmitter. It brings certain facts. It's like a basket. It's bringing everything else is in this affidavit. This affidavit is attached or describes or lists everything else regarding this particular cause. Whether your cause is for civil reasons or criminal reasons, it doesn't matter. Affidavits are an incredible, particularly important part. Again, where does this even come from? Well, back in the King David days, if you know anything about scripture, when someone was brought before the king to promise to tell the truth, somehow or rather, this is affirmed under the spiritual presence of the king, David. So it's like you're affirming in front of David. So affirm David, affidavit, it just kind of evolved such and such. If anyone has a counter to that and has another version of how that could be altered, I'm open to suggestions. Chancellors, judges are charged through the Bible. They're appointed federally from every country, granted, down onto the provinces or the territories in the states. But this is where a loved one sent me a message the other day saying, Darren, I think it was in England, maybe, that Parliament or someone is ministers. That's what it is. Ministers are trying to pass laws somehow to have their voice heard above the judges. So the judges are going to be literally removed somehow, or they're going to be hogtied so bad. The legal system is going to take over so bad that the judges will not even be able to help us soon. When someone asks me, it's like, Darren, is this of any concern to us? It's like, oh yeah, absolutely it is. We got to protect our judges. When we come at them properly, they're the ones that, again, when they're your advocate, when they are your friend, that's a whole different set of circumstances to be with. They look out for us on the legal side through their aperture or their discretion. There's an army of people and apparatus waiting in the background to protect us once we're protected. Oh, well then is that part of the title? Bona fide protected purchaser for value? Yes. That's why this comes in to be very, very, very important here. So if you want, Kim, whenever you're ready, or am I supposed to do this? Am I supposed to share? All right, I'm supposed to share. Well, let's see here. Screen share. Okay, so yeah, we can talk about the affidavit here first.
And the affidavit, loved ones, will be posted on the chat and on our Telegram right after.
So I'm just going to share this, just a couple of little upgradies to the affidavit, just stuff that, I'm just punching on in the background here. Let's see if I can do this better. Okay, so anything I've done in red, this is in addition to what we've already been looking at. So again, this is going to be posted, so don't fret. You can have eyeballs on this pretty soon. But in the opening proceeding here, so this is a special affidavit. And if you want to call this, here's the thing, if we've ever filed an affidavit somewhere else regarding anything to do with trying to protect your inherent rights or protect your equities or restore your sovereignty or any of this stuff, you may actually want to title this affidavit then to be a supplemental affidavit, because you've already got shit hiding around in the background for 1 to 10 years ago. Some of the expressions and some of the notices and some of the things we did in those earlier documents are of relevance. So we're actually going to suggest, hey, this is just supplementing all the shit I've already done. So that's one option if you choose to pursue that. So this notice of intent of action. Okay, so what is it that this affidavit is going to be supporting? Well, ejectment is really important. It's actually going to suggest, hey, we can't get that trustee to move until we eject them. Now, again, eject meant. So we're going to eject mind, right? Meant is, every time you see meant, it's mind. So what are we ejecting from someone's mind? Who are the parties here? What's happening? So in a proceeding to enforce or realize a security under a debenture. What's a debenture? A debenture is like an instrument. It could be a trust. It could be a security agreement. It could be an administrative agreement. A debenture is just a generic term describing a particular instrument, really. Any type of writing. Okay, so now where security listed, I should put in here as collateral, personal property. So now we can talk about, hey, notice of deed of inter vivos trust, because of some of the stuff that just happened in the red. Now we can actually suggest that there's a trust here. And because of this trust here, now we can, appoint private trustees. So now this affidavit's going to go on. So when I talk a lot about, okay, don't bring a whole lot of scripture into our immediate process right now. Okay, again, leave the ecclesiastical stuff out for just now. I mean, I know a lot of that spirit is trying to come out in our process. Yes. But just leave that for now. So other than this, I come quickly. That is right out of the last page of Revelations, I think. Almost the last page of the Bible. Christ is talking about coming quickly. He says it 3 times within like the last page-ish of the Bible. So anyone that's coming quickly to avail themselves of a problem, you're coming in the consciousness of Christ. You're coming with clean hands. And that's why all those other things we're talking about now, they start to take effect. So when I'm coming quickly, based on what? Based on a right coupled with an interest. Now here, at a court of consciousness, or a court of conscience, the court, for redress. We've talked about redress. We know how important that is. Shed that public character. Get rid of it. And that we're seeking complete justice and believe, based on information to be true, and given the character in possession of the court. Okay, what did I just say there? I just said the court is already in possession of the legal character. That is what unlocks the door. And because that legal character is specially deposited or paid into court, securities paid into court. Anytime a complainant or a plaintiff or a petitioner is seeking any extraordinary remedy, what are the extraordinary remedies? An accounting, special performance, appointment of a personal representative. Did I say injunction? These are the fancy ones. These are the ones that kind of set the tone for everything else that's about to happen. You can't get an injunction or an accounting or any of that other good stuff until securities are paid or furnished into court. Now, there's a way to get your securities paid into court. Bryce just did it 2 weeks ago as the defendant. That's the toughest spot you're ever going to be in. Way easier when you're on the plaintiff petitioner side of the court. So we're talking about coming quickly. And then again, because this character is in possession of the court, that warrants the court and empowers it to take jurisdiction in equity to avoid a multiplicity of suits and decree the relief prayed for by the petitioner. This is so setting the stage to some magical stuff that can happen for you in the background. We can express equities in our affidavit. Absolutely. When these equities are facts, that's what we're really talking about here. Facts of the case. What are your equities? What are your facts? Well, here's one. That I am the surety. Again, that's scripture. When you pledge to be surety for a stranger, watch out, because you're about to be snared. And once you're snared, ask a rabbit how often it gets out of the snare. Not very. Once you're hooked, it's tough to move. Among other sureties, okay, that suggests that there's co-sureties in the background. Who's a co-surety? If you're the surety, guess what? There's a co-surety also hiding back there. Who is that? That's the crown. The crown is the principal debtor. The principal debtor as a co-surety means they're also responsible for something here. They also their asses are on the line too. If we come forward as the surety and make stipulations, again, Gibson's book talks about this. I can pull that out in a little bit later episode here, where once the surety comes forward and stipulates, because again, the surety is a party to these contracts, or is a party to the arrangement going on here. Sorry, I'm just going to make the screen a little bigger. We got the creditor, the creditor, the debtor, and the surety. 3 positions actually to every contract. We didn't know that before. Dean and I have talked for years about, creditor and debtor, creditor and debtor. We missed one of the key roles. Can have a severe impact on how we move things forward. Missing one of 3 pieces. Come on. Okay, so, and that's subsequent to some crazy legal thing that happened when I was born. Somehow I became possessed of this legal interest. No one seemed to be able to stop it, Your Honor. I seem to be stuck with this thing. I'm not denying it now. I'm just going to actually rely on that as a fact. Yes, Your Honor, it's a fact. I did take this security when I was warned not to. I remember mine saying on it, do not use as personal identification. And yet here I go. Your Honor, I'm admitting guilt to that fact. Yes, I did go. I did go apply for this social program. Yeah, I did. And I'm at fault. And I'm here to correct that fault, so that a default something can happen. Once you admit the fault, a default can now occur. That's the switching of positions actually in the background, loved ones. Okay, so subsequent to this problem's perfection. Now this problem ought to be dealt with and vested. And that ought to be vested in new trustees. Relief ought to issue. Now, this is a chunk of legislation right out of the Law and Equity Act, again, for British Columbia. So, again, we appeared in person. We had to because we're deemed to. So let's just bring that person with us. But showing up as the man or woman is going to really help to clarify the two genres or the 2 realms. And what we're doing right here, Your Honor, we're basically bringing through our affidavit. We're suggesting we have a conflict. We got a conflict with what's going on. Yeah, Bryce was saying that to the judge the other day, but he wasn't quite conveying it properly. We're seeking relief against penalties and forfeitures. Remember, equity abhors a forfeiture, so we got to home in on that forfeiture right away. You forfeited your rights when you were 16 years old. So did I. That's the big problem here. So we're asking for relief against that problem, and only a court of equity can provide this type of relief. Why? Well, look at this. The court may relieve against all penalties and forfeitures, and in granting the relief may impose any terms as to costs, expenses, damages, compensations, and all other matters that the court thinks fit. Okay, that's legal talk for them saying, yeah, once someone brings a conflict or approves that there's a forfeiture has happened, they're entitled to relief on the equity side. So this should actually read number 2, but that the petitioner seeks the following orders and reliefs under Section 37 of the Law and Equity Act, respecting or talking about vesting orders. Section 37, where the court has authority. Whoa, stop right there. Where does the court get the authority? You're presumed to be acting in person. You're deemed to be dead and just a dumbass. You're deemed to have no defense or cause of action at all. How could you? You're dead. So where does the court get the authority from? Well, here's where. When you vest that certificated security, perfected, value added, bona fide purchaser for value, this little transaction, this little event, deposited especially with the court, is where the court gets its authority from. It's sitting on a valuable instrument all of a sudden. It's sitting on a financial asset. This thing's got some mojo behind it. Like a judge can actually do some stuff with this. That's where the authority comes from. So if you don't do a lot of that other process that we're describing, you'll never truly be able to empower a court to help you on the equity side. We got to give something to get something. Now, for selfish people, they got a problem with this. They always want to get first. And if they're satisfied with those results, then they'll give. Equity says, well, you're going to be waiting for a long time. That's why the charitability of the whole equity side of the spectrum is important. So what we're doing here, okay, so this little thing goes on to say, where the court has authority to order the execution. Order the execution. So we show up with a deed or a conveyance or a contract. Again, we've talked about contract, or a transfer or an assignment of any property. When it says any property, guess what that means? It means anything. So when we show up with a deed, which we're doing, empowering the court to what? Execute it. The court is the one that stamps our idea, puts its seal on our scheme, on our little plan, or our crazy little idea here, expressing our equitable interests. The judge and the courts will approve it. Once it's approved, that's when the gates open up and everything is now going to happen for you. Without the court approval, this is way tougher. Again, been in the trenches for a long time to know and finally come to the conclusion, hey, you know what? It's better that we bring the courts in to help us deal with this stuff so that we can avoid a shit ton of mess and problems later. It's getting to the point where we're getting tired. It's getting to the point where, hey, if we don't get some closure soon, it's going to start to feel like, I failed. That's not going to happen. So, and this thing goes on to say that the court may, by order, vest the property, whatever. Okay, that's why I'm saying vest. So the court needs to see property that's divestable. The court needs to see some type of property where it can grab it and attach it to a new trustee. If you don't describe what the property is, the court has no freaking clue what you're talking about. That's why we got to establish that pretty quickly in all of our paperwork here. So the court can vest your legal problem in the new trustees or the person, and in the manner and for the estates as would be done by that of deed. Ooh, that has an equitable ring to it. Conveyance or contract, assignment or transfer, if it were executed. That's suggesting the court has the authority. It has everything it needs to act on your behalf, to get your shit rolling for you. Why? Because you showed up as a bona fide protected purchaser for value without notice. Again, what's the without notice? I was the grantee, now I'm the grantor. Between those two capacities, Your Honor, we're still without notice that there's a third estate or a third interest kicking around in here. We believe that we've encompassed everything and that we're properly dealing with everything right here. But if there's a secret estate out there, if there's a secret interest claimed, or if there's a lien hiding somewhere that I'm unaware of, I'm just going to proceed that it's not there. Because if it's not brought to my attention, if I wasn't directly served with notice properly saying that there is a third estate floating around out there, I can presume and I can proceed that there isn't one. So the court is in possession of securities paid into court and is warranted thereby. That's a pretty deadly statement. When the court is warranted at an equitable level, that means all the indemnifications are in place. That means, hey, once the trustees start acting, they're protected. As long as they don't F up too bad, they're allowed some grace. They're allowed some gray area as well. As a matter of fact, the trustees are the ones now going to bring the case to the judge and say, hey, I just got privately appointed with this. I don't know how to proceed. I don't know what the hell to do. This is all equitable stuff, but all I know is that I'm indeed possession of a birth certificate with a coin and a trust expression attached to it. And because I'm in possession of that thing under this lawful assignment or transfer or conveyance or delivery, Your Honor, this feels important enough that I got to come to the court for directions here. I don't know what the hell to do. That's the trustee's job, to go get directions on how to proceed. Trustee land. We don't need to worry about that. So again, this is all based on the stuff that we talked about yesterday. And I don't think I changed anything after that. So again, when I'm dropping in this red stuff, loved ones, even tonight, when this meeting's up and over, I'm still going to fine tune some of this stuff, still try to slice as much as I can off of this stuff. But you see how there's going to come a point where, that's such a good statement. Frick, I basically understand what that's saying. That is dynamite. I do want that in my affidavit. And it gets to the point where shit, you actually can't really condense it much more than a page or two. Getting it tighter than that, we're going to work on it. But there's just so much meat that the court wants to see. And the more of it that we can provide, the better we're going to be. So I'm going to switch now to this, what I mentioned in the beginning here about why is the bona fide protected purchaser so important? Why is this transaction integral for what we're doing? So I'm going to stop sharing this. I'm going to suggest that's what I got to do to myself. Okay, I think we're good. So let's just tear right into this. Okay, now again, this is written by a chancellor. These are some smart dudes from back in the day. So we're talking about priorities. As soon as you establish you have priority, guess what? You have your control that I'm always talking about. You don't have your control if you don't rank in priority. There's a number of ways that we can establish how we rank. That's why registering all this crap at land titles or the county recorder's office does become very important. That's what's establishing this transaction has been registered or recorded. Boom. They seal it. They put a time, a date, right to the seconds. That's how we all establish who has priority here. So, okay, so just checking this out here. Priorities and bona fide purchasers. Again, I just talked about priorities. So priorities and equities relating thereto. Assignments, how affected by priorities. We're dealing with assignments and the equities relating to thereto. 75, bona fide purchasers and their equities. Number 76, equities of purchasers, how affected by notice of prior claims. So this is going to tear this. I think there's 8 pages here. So again, this will be posted so you guys, everyone can take a peek at it. But just the way that this thing is going to roll out, it's suggesting when the owner of a legal estate, there you go, we have to prove we're the owner of a legal estate. When this guy or girl shows up to convey, that means move it in good faith, all of the interest attached in that thing to another party, it is manifest that he cannot or she cannot, by a second conveyance of the same estate to a third person, vest it. Okay, so what that's saying is, hey, once you do this once, you can't alter it. It's locked in. It's done. Which is why the clerk, the registrar, was saying to Bryce the other day, once you do this, you can't go back. You can't come up with a reconveyance of the original conveyance. You can't say, oh shit, I made a mistake. I didn't mean to convey that to the proper trustee. I would still like to be the trustee, please. I'd like to reconvey it. No, it's lost. It's gone. It's done. Registrar said straight up, once you do this, that's it. It's over. Huge. Bryce sacrificing himself to go to jail for a day and a half or whatever that was worth it to get that single statement out of that registrar. As a matter of fact, Bryce, if I had to send it back to jail for another week just to prove how valuable that statement is, I would. Point is, that shit coming out of the registrar's mouth is gold. Seriously, folks. Huge. I know another good friend of ours, Marcus from Servant King, that gentleman back in the day, he was also talking about redeeming that certificate of security, taking it back to where it was issued and trying to redeem it. I don't think he did it quite right. But back in the day, there's another gentleman that was already onto the significance of, hey, this thing needs to be redeemed. Redeeming it is everything we're trying to do here. Surrendering our interest. This is where I'm saying, when we prove that we're the owner of a legal interest, how do we prove that? Okay, well, let's just talk about that. You got the birth certificate in your hand, don't you? You've already done all these contracts throughout your entire life on its behalf, haven't we? Can we not prove we have a pretty vested interest in that thing? Can we not prove we're already acting in person? Can we not prove we're already possessed of this thing? That's enough to suggest that you're the legal owner of it right now. You pay its taxes. Only the owner pays taxes. It's part of our problem. We all wanted to show up and be the owner of something when we should have said, no. I'm going to transfer that interest back to the actual owner, which is consequently what happens as soon as we put this special certificate with the coin and all this other awesome stuff attached to it. Once we put it into the possession of these trustees, or once it has fallen directly into their custody, they are now supposed to go to land titles or the property registry and state that they are the registered owner of this thing, and that they're now making application on its behalf to become the registered owners. See, boom, this is what locks them in. And only the surety can actually pull this off. That's why stipulating as surety is important. And that's, again, another thing that I'll talk about. Gibson's book is fantastic for showing us here. But you know what, I'm just going to keep going on here. So we're talking about priorities. No one can transfer to another a greater right than he himself possesses. So there you go. We're going to suggest that we had a whole undivided legal interest. That's what enables us, or that's what gives us the power to move that. How do you move half of something? You know, you gotta move the whole thing. That's why we call it an undivided interest, or 100% interest in such and such legal title. So we got another neat little thing here talking about, okay, so a similar rule of priorities prevails in reference to the acquisition of equitable interests. Boom. Loved ones. That right there. Acquisition. Acquisition how? Acquisition through a merger. Remember, you all saw Pretty Woman, that movie. Remember Richard Gere trying to style the hottie here, says, hey, baby, I do mergers and acquisitions. That's why I drive this fancy car, which is odd because she had taught him how to drive it, which is kind of funny. But point being, acquisitions and mergers, you don't get the acquisition without a merger. Got to prove there's a merger going on here then, obviously, to acquire our equitable interests. Yeah, we'll take that. Okay, so then this thing goes on to talk about maxims right away. Where there are equal equities, the first in order of time shall prevail. That's our shit being recorded or registered at the land people place. Oh, and this goes on to superiority is achieved when we have priority. The maxim would read superiority of right gives superiority of right. Wrong. That's the wealthy, the elites, using their superiority of their bank accounts to oppress and control everybody. Equity says, no. We're not going to let the corporations do that. But if no one comes forward and defeats this whole corporate idea, if we all stay within this corporate construct, we're screwed. So this is why I think we can probably go down a little bit there, Kim. Again, they're talking about a lot of maxims in here. We're talking about estates, equitable interests. Okay, hang on there, Kim. Look at this one. 3D here. It's kind of funny that it's 3D. The legal title being outstanding. Yes. Because you have the legal title, it's outstanding. And I don't mean that in a good sense, as in you've done an outstanding job. Congratulations. No. I mean, you have no standing because that thing's outstanding. So we need to perfect our equitable estate, or a mere equity in the other party, or where among equitable interests of a like intrinsic nature. There, that's how a few of us can come together and join forces and get our shit perfected and endorsed and approved and decreed by court. Where you have like intrinsic interests and natures, one is affected by some incident or quality which renders it inferior to another. Priorities of attachments and judgments and executions. Priority in time prevails to the same extent when liens, we were just talking about liens, are acquired. Yes, when I was answering loved one's question yesterday, is this a lien? Yes, you acquire the lien interest in equity as soon as you perfect your stuff and transfer it, get it out of your possession. That's the curse. We never used it properly in the first place, which is why we're being punished. So we're attaching writs, and in all such cases where the right of the petitioner attached either directly by the filing of an attachment bill. That, again, this is just more fancy words for a petition. Anytime you see the word bill in the equity side of things, they're just literally talking about our petition. So this thing goes on and on and on. You know what, Kim, just scroll down to this number 3, this equities of liabilities of purchasers. So we're talking about in applying these rules, it becomes important to know when one equity is superior to another. How do you acquire a superior equity? The moment you attach an interest and a silver coin as consideration to a particular certificate, boom, you just landed yourself an equity, my friend, and a freaking big one. Courts of equity recognize no inequality based on form or mode of creation, which is trying to say, hey, as long as we do a decent job at doing this, they're going to take it. Provided that the equitable interest is perfected. They're right there. Okay, if you don't perfect your shit, it ain't working. Done. Every time we hear these little stories of, oh, I just got a little victory in court. How did you perfect your interest? What are you talking about? Okay, well, if you haven't perfected your interest, your little legal remedy that you just got on the at-law side, that's an illusion. Trust me. You're not going to get shit all for equity until you perfect your interests. And look at this. Perfecting the interest and is based upon a valuable consideration. There. I never need to explain this one again. When people say, oh, Darren, what the hell's the point of the silver coin? As a matter of fact, I argue with Dean about this one a lot. He says, oh, you don't need the silver coin. Okay, Dean, what valuable consideration are you attaching to your contract as a fiction? Don't say love and affection because you're not capable of expressing it. What else you got? Jeopardy music. Do, 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 do. Nothing. Alex, I don't have an answer for that. The equity acquired by you who has been misled. Where did we get misled? Oh my God, really? We could write a book on that one. So this thing is superior in interest in the same subject matter. What's the subject matter of this freaking birth certificate? That's the common subject matter that we're always talking about. Was willfully procured. That's you taking it and identifying as it. That's you willfully procuring it. That word procure, pro, is positive. Cured means after 30 days, this baby is locked down and it's encased in concrete. And I don't care how much you hammer on it, you're not getting through. It's substantial now. So this thing goes on, says, so now we're going to start talking about the fraud. So look at this. Equity regards as constituting fraud, either actual intention or misled. What's actual intention? When we actually showed up with a birth certificate and we said, yeah, this is me. That's you actually applying your intent to apply for a birth certificate. So we got to start to fix some of this stuff, loved ones in our affidavit. This is what we're talking about here. So if you want to roll down a little bit more, Kim, I see another good one here. And forgive me, loved ones, I didn't have time to go through this. So I'm just, as I'm reading this with you right now, this is, again, just me seeing again. A purchaser without notice of a trust. There. That's what the notice is suggesting. You, as the purchaser, is without notice of any other trust out there, whether expressed or implied. We're just going to assume that this thing's up for grabs. Becomes himself a trustee for the beneficiary as to the property purchased and is bound in the same manner as the original trustee from whom he purchased. Okay, so if you just showed up now as the purchaser and you're dealing with the original trustee, who's that? Doesn't that sound like it should be the state? The state is the original trustee. They're the co-surety. They're the principal debtor, all under a mortgage that we volunteered to make the monthly payment for till we die. Equitable liens for vendors. This thing rolls on. We can talk a little bit more. Kim, just keep scrolling. Exceptions to the rules of priority. Okay, well, here we go. While as between successive purchasers or assignees of an equitable interest, with us, there is no successive purchases or assignees. It's just you. There's no one else. You're entitled to the preference who first gives notice of the assignment to the debtor. Boom. As soon as we say, hey, John and Jane Doe, I actually don't care who you are. You're all trustees. So because of that, I'm now allowed to assign to you the debtor. You're the principal debtor. I'm the one that showed up and perfected my interest. I'm the one that got cleaned up. I'm the one that made this thing super valuable, not you. I did. And because I did that, I'm entitled to stuff in return. Specific performance and the appointment of a personal representative. So again, this is just going to be going on. It's talking about, for 8 pages, why the protected purchaser is an important position to hold on to. It's an important position to exact from, because you've just purchased something they didn't. How does the state match your contribution? Because again, this is all we're doing here. We're making a contribution in silver and we're attaching it to a security. That is called a contribution. And because you've contributed, that means the other party now is also liable to contribute. You raised the bar. You brought in value. They have to bring in something as valuable now to match you. Oh, but they can't. Because you're dealing in silver, they're dealing in debt notes. You see how they're now obligated to you forever? They can never truly pay back what is owed to you. Very incredible position to be in. This is the subrogation happening. This is why a successive interest holder is appointed. Here, you took my legal interest and I'm succeeding it to you. I don't want it. It's a big deal, loved ones. Assignments is talking about assignments. Where an equitable interest in land is, where did I just see that? There you go. Yeah. Where an equitable interest in land is created. An equitable interest in land is created. How about where an equitable interest in real estate is created? Or how about where an equitable interest in personal property is created? Or how about where an equitable interest in chattels real is created? Or how about where a personal property related to a personal trust expression results in the appointment of personal representatives? This is all going to be what? Secured by a transfer of the possession. You know what? I could literally just close my laptop and just let you all chew on that for a minute till tomorrow. You see the significance of that one right there? Is secured, the security, the certificate secures the transfer of the possession. Nah, now we're talking. They are so stuck with that legal interest, they can't get out from under it. They're done. Silver bullet, silver stake, vampires, boom, they're stuck. They're going nowhere for eternity unless you release them of their obligations and duties. The only thing that separates them now from being obligated to you is their death physically, or yes, they can come forward and say, hey, Your Honor, I desire to be relieved of my and released of my duties respecting this trust, but please, in my absence, appoint new trustees. Boom. They have to go through that so that your trust is never without a proper trustee. That would defeat the entire purpose of everything we're talking about here. And trusts are super important. Scripture talks about trusts a lot. Our Creator trusted that we were going to make the right decisions. And if we did, we'd get to enjoy the benefits of milk and honey for the rest of our lives. And if you chose unwisely, here, all this shit's going to happen to you. It's laid out. So again, possession. Okay, look at this one. And that one actually went to say, or by reducing the agreement to writing and having it registered. But no such safeguards exist in case of assignments of a chosen action. So that's why we're kind of staying away from the chosen action. We're just suggesting, hey, I've got a security agreement or I've got an administrative agreement. I have a private agreement going. And in that private agreement, I've duly appointed, I've duly nominated, and I've duly elected this particular person for these particular things. And I've vested a legal interest in them, provided them with the perfected security, made it all beneficial for everybody. They're stuck. The legal title, which is analogous to the possession, remains vested in the debtor, the trustee, or the holder of the fund, while the creditor or beneficiary, boom, now you know. Gibson just said so. The beneficiary is the same word as creditor. Essentially, for the essence of what it is we're talking about. Again, I don't really use that word creditor a whole lot. And you know what? Maybe I should. I don't know. Creditor or beneficiary. Even after one or more assignments of all his interests, continues clothed with full apparent right to make further assignments. That means, once you assign this thing once, okay, this is why they're laying it out like this. We only want to assign a portion of that undivided interest. Here, lawyer, you take a portion of this life estate. Here's another lawyer, if you wanted to go to multiple lawyers, or just pick one law firm that you like and start making private appointments all over the place. Get these trustees to start dancing. Once you stick that security into their possession, they're stuck with it. Because here's why. Imagine they tried to actually send that birth certificate perfected back to you by registered mail. Okay. Oh, such and such gets a registered mailing in your name, show up in the mail. This is why you want to accept that mailing as grantee. Daniel-grantee. Boom. So even if they did try to send you back everything you sent them, you just perfected it again by accepting it as grantee. Now you got the whole thing again. And now you can say, hey, Your Honor, look at this. I sent this whole package in a conveyance to this lawyer, and he blew it off. He said, I'm out to lunch. And he told me to get some legal advice. So you know what, Your Honor? I'm bringing this to your attention under an urgent action for trust enforcement, even breach, for you to get involved and you to adjudicate and you to lay some equitable smackdown. Because from what I'm looking at, Your Honor, I have something called a successive assignee right there. And that it is valid and it is effectual. And it ought to render an action because I've paid valuable consideration. And the assignee ought to, in good faith and for value, obtain precedence or power over others where the equities of this successive assignment being otherwise equal, the priority among them, the trustees, is all figured out by the date in which we made this assignment. We literally make the assignment the day you put your squiggle on the birth certificate. That's truly the effective date of the assignment. You express your interest right there. So this thing goes into, it talks about where you got to give notice, where you don't got to give notice. And again, this is where we're saying, I don't need to give notice, Your Honor, because I'm unaware of any other party, a real party in interest, that has any say or any interest in my equities here, Your Honor. That's why the court is able to streamline and give you instant remedy, like right now kind of speed. If you were to get this shit brought before a judge properly under an urgent circumstance in chambers, he can literally cut you your order, I bet you within an hour of you filing all this shit properly. That's how fast this can happen if you do it right. Why? Because no other man or woman can appear to object to what the hell it is you're doing unless that other man or woman parted with the silver coin, attached it to their birth certificate, brought their bond to the table to challenge what you're doing. And guess what? If it's proven that that party B had a fraudulent interest in what you were trying to do, you can literally take their entire estate. Because you're bringing your entire life estate to the table, another man or woman would have to bring their entire life estate to the table to challenge you, which means they're vulnerable. Whoa, seriously? You want to go there? Why the F would you ever try to do that? No, see, any man or woman in a right frame of mind, I would never get in the way of Big Kahuna's trust expression to get all his property interests landed and have it decreed by the court. What the fuck? As if that would ever happen. And only another man or woman who's perfected their shit has the power to even do that to Big Kahuna. Do you think a person can do that? Do you think a person, a legal character, can get in Big Kahuna's way? And the judges know that, which is why the judges can issue instant remedy right now kind of speed. It's happened. It's happened to the point where, again, when they say, hey, what's the remedy you want? Well, Your Honor, according to the perfected securities paid into court and in the court's possession, and in the good faith execution thereof, I believe upon information based, held in or referred to Section 34 of the Law and Property Act, the Law and Equity Act in British Columbia, that property ought to vest in new trustees. Just off the top of my head. If you wanted to sit down and create these types of little scenarios, do it. Talk about perfecting something on such and such a date. Yes, and yes, Your Honor, I did. I've attached that instrument to my affidavit. See Schedule A1 or exhibit marked A2, however you describe it, whatever. But again, it's the affidavit that opens the door so the judge can see all this stuff. When they actually suggest that we can create bona fide proper affidavits in the legal world, when we're all acting in person, I'm going to say that's nonsense. That's all a freaking illusion. I'm going to suggest that a fiction can't even create an affidavit. That's all an illusion. It has to be. So this thing, look, it goes on to talk about all negotiable instruments, whether negotiable by the law merchant or made by statute, may be transferred without notice to the makers. Aha. That means once the maker or the issuer put you into possession of that birth certificate, it wasn't implied that you had to give them any notice of what you were about to do with it. No. Because that's all they already know. You got one of two options. That's how the game rolls. And we all chose unwisely. Could have chose wisely. That's what we're doing here. So they know as soon as we start coming forward to correct this thing properly, we actually don't have to give them notice. Fuck, it's what we should have been doing the whole time. Which is why we're coming forward now as the bona fide protected purchaser for value without notice. Because we don't have to give notice, we can streamline the shit out of the time frames here. Judge can deal with it fast. Got to put him in possession of the security, though. So it's going to talk about why and sometimes where we do want to send notice. Equities of the debtor against the assignee. It's going to talk about a whole bunch of trust stuff, forms and assignors and defenses and obligations itself. Release the condition of accounts between the original parties. Look at that. Set off, payment, release. Dynamite stuff, people. It is essential, however, that the equity in favor of the debtor, let's see how this one finishes, Kim. Okay, should exist at the time of the assignment. Well, there's a hint. Focus on that one. Prove that one exists. And we're laughing. So to obtain any type of a payment, a release, or obtaining a set-off, again, this is where nothing is going to get into the way of the rights of the assignee, the debtor, the new trustee. Once you do this, that entitles them to equities under the rule. Again, the trustee actually gets some equitable relief here too. They get to administrate an estate. They get to make a shit ton of money. I don't remember where I saw it, but there was some incredible language talking about he who administrates estates in the background privately for vested interests relating to life estates may come into serious amounts of capital. That is a very lucrative thing to do, which is why Richard Gere was doing it. Acquisitions and mergers. Look at my fancy car. We're doing the same thing. Oh, look at this. Down about halfway in the page here, we're talking about without any notice of prior adverse interests. Well, then why are we bringing adverse claims? If there's no prior adverse interest, then maybe we want to slip an adverse interest in here then. That's why I attached that word. I took a little bit of flack for that from some heavy hitters, in this field that's been doing this shit for a while. Oh, Darren, why do you want to bring an adverse claim? Well, how come you're not just bringing a claim? And then you even get you shouldn't be making a claim at all. It's like, okay, well, one of these three doctrines or principles is going to have to work. And I'm just choosing this one. And I think the adverse possession and adverse title, adverse interest, and adverse claim is actually kind of important. Because from the research I've done, an adverse claim is directly speaking
to a financial asset and a special interest in that financial asset. I know what the financial asset is once we do it. So again, just look at some of the language that he goes on here to talk about. Man, there's a lot of meat here. There must have been a purchase. This is the very cornerstone of a defense, if you're using it as a defense, or maybe we're using it as an empowerment for the petitioner to come forward. An innocent purchaser, manifestly just to prefer the defendant or the plaintiff if he's bringing this equitable title, manifestly. It's talking about having in addition both the possession of the legal title where the equities are equal. Besides the complainant was guilty, okay, it's talking about some other shit here. Evidence to give the purchasers notice of rights when a loss must fall on one of the two persons. It should be borne by him whose act or negligence caused it. There you go. When you cause a situation of negligence, that is proof when you were 16, you didn't know what the hell you were doing. Look what you were negligent of. Breaking the first commandment and then going and starting this whole shitstorm. We could have done something much, much easier. There must have been a purchaser. There must have been valuable consideration paid. The conveyance must have been taken and the consideration paid before notice. The prior adverse equity. Oh, look at that. We have something called an adverse equity. What the hell is that? Someone do some digging on that and let me know. But I got a pretty good gut feeling on that one. Purchasing, blah, 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 blah. This shit goes on for eight pages of this stuff, telling us why the protected purchaser position is so important. And I know I'm running out of time here, so we're just gonna start to wrap it up like this. This is why we want to be talking about having this position of the protected purchaser. We want to start talking about evidence that points and can make this evidence appear before a judge. Where it appeared before the court on such and such a date, that's when your shit showed up. Was that it, Kim, or was there more for this one? Or
I think there's a few more pages, but we can share later, or they have access.
Yeah, okay, cool. So again, identifying this position of the protected purchaser right away in our affidavit is going to lend itself to be dealt with in the deed and the petition. All three things here are dealing with the same ideas, the same you being this protected purchaser. This is why they took the silver and gold away from us back in 1933 or whatever the hell it was, so that they made it extra hard for an enemy to perfect his interests and become a friend. They wanted to keep us at war. They wanted to keep us belligerents, keep us enemies of the state. Because when you're an enemy of the state, under occupation rules, they may control you. They can tell you what to do, dictate, stick stuff in your body. And we have no voice. That's been granted away. And because, as suggested earlier there, we've made an unconscionable decision. And as such, we are subject. We must bear the burdens and the punishments of our decisions. We can jump up and down and say it was fraud all we like. Yeah, we know. We didn't understand what the hell was going on, which is why we're coming forward to correct the freaking problem now. But just don't be going to the at-law court to do it. If you're a defendant, start talking about it, though. Get your equitable pleadings on the record. Start getting it down. Well, Your Honor, because I'm not being compensated and because it's against my better conscience and it might even infringe on my civil liberties and my religious beliefs, I can't act in person. And I'm going to keep suggesting I can't act in person until something is dealt with here. I'm conveying and assigning the 100% undivided legal interest to the Crown, and any agent of the Crown is thereby bound to this agreement. Whoa. What did you just say there? You just bound every freaking trustee out there to your particular trust. I can express a trust in Canada, and it's still going to work in England. Wherever you are, it's still going to have the same force and effect all over the world. It's good against all the world. It's kind of another legal maxim. Once we start moving these property interests around, once we get on the protected side, remember, the militaries do not get involved in matters internal to that corporation. exclude yourself from that corporation. Now the military will protect you. Okay, loved ones, I think we jumped on this one quite a bit. Take some time, put some eyeballs on what this this protected purchaser is and why it's so important, and why, because when we refer to it a few times here in our affidavit and so on, you're going to understand the significance of it. It's huge. It's really, really big. So tonight, again, we're going to bounce back now to the petition, and I've already got it at least 1/3 to half filled out. So now you're going to see an actual stylized petition and some of these things we're talking about. I'm basing this petition out of the Law and Equity Act in British Columbia here, because we're coming forward to enforce our equities. And pursuant to number 34, the surety is entitled, the surety who discharges an obligation is entitled to relief of penalties and forfeitures. I don't know, whatever, something like that. We're going to go over it. You're going to see it coming forward. Putting that court into possession of the thing is what takes the handcuffs off of us. Hey, loved ones. Chat you soon. Love y'all.